All right. Test, test. All right, that should be good. Play with that, Jordan. So the first item is to look at the personnel order. It's got an echo. Jordan, you going to work on that? We'll go into a brief recess for... No, that sounds better. Is that better? How we doing over there, Marianne? We good?
Sounds okay.
Yeah? Okay.
It's not echoing like it was.
Okay, good, good. All right, so you all have the personnel order in front of you. The custodial position in the maintenance department was one of the things that we were going to discuss, but after the hiring process, I believe the personnel committee's been made aware of everything going on in that hiring process, and we have the candidate recommended by the maintenance director, Rick Wade, who is here if you have any questions for him. But if not, I would entertain a motion to recommend to the full fiscal court for the approval of the personnel order for tonight.
Motion.
A motion by Squire Gentry, second by Squire Carl. All those in favor, please vote and signify by saying aye.
Aye.
Aye. All right. Motion carries. The next item is Officer Emily Katner has requested that we move Eleanor Green from technician to officer, giving her full officer status. That is a status adjustment and is not any additional pay. And I am in favor of that. She's made that request, and I would recommend that the personnel committee recommend that to the full fiscal court. Motion by Squire Carl.
Second.
Second by Squire Gentry. Are there any questions? Officer Katner will not be able to join us tonight. She's got to go to a funeral, so if you had any questions for her, you could call her prior to. But seeing no other further discussion, the motion to amend the status of Eleanor Green from technician to officer in the Animal Care and Control Department. Please vote and signify by saying aye.
Aye.
All those opposed, nay. That motion carries as well. The main reason for this personnel committee is in response to the state of emergency and severe winter weather. We were closed on Monday and Tuesday, but we did not require any of our employees to take leave for that day. And therefore, anybody who worked the response, I'm going to recommend that we have 2 floating holidays that would be available for anybody who worked those 2 days, Monday and Tuesday of last week, that they would have the opportunity to use that floating holiday days up until June 30th, at the end of the fiscal year, at which time they would expire. The normal rules would apply. That vacation time would have to be scheduled. It'd have to not be, it has to be approved, scheduled, all that sort of stuff. But this is a way to essentially make those folks whole that had to work the emergency response. And so we're talking about road, EMS, the jail, sheriff's office, maintenance, departments like that. So I would open up the floor for any questions or discussion on the proposal for 2 floating holidays paid to the emergency response employees. Seeing none, is there a motion to make that recommendation to the full fiscal court? Motion by Squire Carl.
Second.
Second by Squire Gentry. All those in favor, please vote signify by saying aye.
Aye.
All those opposed, nay. And the motion carries. And what I will do is I will draft the criteria for that once it's approved, if approved by the full fiscal court, let you all review that and then push it out to all the employees so that they can begin to take advantage of it. Madam Clerk, is that our total sum of our personnel business?
It is, Judge.
All right. Anybody else have anything on personnel? Seeing none, then we will adjourn the personnel committee. And we will reconvene into the ordinance committee. Madam Clerk, do you have the roll for the ordinance committee?
Squire Downey. Squire Blackford.
Here.
Judge Executive K.
All right, so Squire Blackford and Squire Blackford and Squire, I know Squire Downey is unable to be here due to a work obligation, so we actually do not have a quorum to take any votes. So these matters will be for discussion for the ordinance committee, since Squire Gill and myself are the only members present. Would that be right, Mr. County Attorney?
You cannot vote.
We would have to have
Yes,
three.
You would have to have the three, yes, Judge.
That is not a problem. So I want to go ahead and, since we have several members of the court here for review, I want to go ahead and talk about the proposed second reading of zoning map amendment for 9042, 9048 Clifton Road, A1 to A4 district. There is it doesn't appear that there's any issues with that. Does anybody have any questions or comments regarding any of those, any of the issues or anything related to the zoning map amendment 9042, 9048 Clifton Road? That one seems to be in order. Okay. We have two other map amendments which are of importance that we need to work on today. The proposed zoning map amendment for 3081 and 3151 Cummins Ferry Road, A1 to A4 district. Director Hunter is with us. Director Hunter, just for informational purpose, will you just kind of give us a breakdown of what that zoning map amendment is proposing to do?
It's very similar to the one you just discussed. To make them eligible to subdivide the farm.
And what is the proposed subdivision of the farm?
Just cutting off a lot. They weren't clear, just sell it, build a house. They weren't. Just
And
have
that's
that.
a 6 acre tract of the
6 acre tract.
62 acres?
And then the rest of the farm would just stay A4 and its configuration. I have an exhibit of that because I got my December. Do you guys want me to show you that on the
Please.
screen? I know they're in your packet, but I've got.
Yes,
exhibit of
please.
that. Okay. If Jordan gets me to the right screen there, and I will get to that so I can show you the. So this is my actual PowerPoint that we used from December 19th, where these two zone changes were heard, as well as the text amendment we're going to talk about. And we did several things at that meeting, but let me get to this one here. We did several in-family plats, as you can see, 5 or 6 that night. Development plan, did a zone change in the city, and then this is the one, I believe. Let me make sure. Nope, that's the other one. They're out of sequence. This is the Cummins Ferry right here.
That's it.
So it's this property right here on Cummins Ferry. It's got the blue dot up there on the screen. This kind of just shows looking into the property there. And then this is the zoning map that shows it's zoned A1. You see some A4 that's in the general area where property's been recently rezoned. This is a zoomed out shot that shows you some other zones that are happened in this area of the county. This shows you the small community footprint, and you see the blue dot. So it is in the small community radius as designated by the comprehensive plan, which means it's eligible for an A4 rezoning if it meets the comprehensive plan. This is the zoomed out shot of those radiuses in the county, and this is their exhibit they turned in. So you can see the farm up there, and the left-hand exhibit shows the farm, and you can see how they're carving off that frontage on the eastern edge of that property. And there's a zoomed-in piece of that tract. But they did not indicate what's going to happen on the 6-acre tract versus the other part. So that technically is their development plan right there. So the Planning Commission reviews it for compliance with the comprehensive plan, which clearly it's in the radius, and then it met several goals and objectives of the comprehensive plan. And so their recommendation was for approval to rezone this from A1 to A4. So it's interesting, that night of the night of the Planning Commission, we did about 6 plats that created several lots, and then we did 2 zone changes that were also intended to create lots in the county. And this was one of them. So this just goes from 1 farm to 2 lots at this point in time.
And Squire Brown, this is in your district. It's an application seeking to rezone 62 acres from A1 to a A4 small community zone for basically creating two tracts, one 55.8 acres and the other's 6.1 acres out of the total of 62. And the existing residence would be contained within the smaller tract.
Correct.
So I'm just giving everybody the information, and
They had an attorney represent them at the meeting, which I believe submitted findings that I believe were in your packet. It should have been, yeah. There was no opposition at the hearing.
no opposition at the hearing, and then there was one nay vote. Is that correct?
I believe so. Yeah. Yeah, there was no formal opposition, but there was one. And I won't speculate on that. Well, I know what it was, but some of it was the rest of the farm, by going to A4, makes it potentially eligible for further division. The goal was to make this split, but when you zone it all to A4, if you can make your frontage work, you can end up cutting up more lots down the road.
Judge, could I?
Mr. County Attorney.
Did I see that one slide correct? And if it went A4, it would be contiguous to some property that's already A4, so it would make a large, I think there, yeah, right?
Not
quite.
contiguous, one parcel over, but
It's one parcel over,
several
okay.
tracts of A4 all through the small community, as well as other zonings. As you see, there's R2, B1, R1B, a lot of different zones in this particular small community footprint. But yeah, there's an A4 tract that's been zoned 2 lots to the east, 1 lot to the east.
And to clarify, that's what was presented, what is likely to happen, but this is simply to determine whether or not it should be changed to A4. Doesn't say, and that will then necessarily happen.
That's right. The goal here was to be able to subdivide off the 6-acre tract off the A1 parcel, which necessitated the rezoning.
And Mr. County Attorney and Director Hunter, can you just give the committee and the court an understanding of what our responsibility here is and how much time we have to act or take any action?
If you want to start taking
You can, sure.
Well, your responsibility, of course, as with any map amendment, is to review the record. You should vote. You don't have to, because operation of law will kick in after 90 days if you don't act upon it. But again, it is different from a text amendment. There is a time frame here. You can, of course, just simply go with the record as provided. I don't advise this, but you can always have your own public hearing and entertain new and additional evidence if you wish. But where we are, and what is typical, is this has been presented by the commission, and you have the record, and you would typically at some point direct me to prepare this for a potential first reading. A first reading doesn't lock you into approving it, which would take a second reading. Again, I think what Mr. Hunter's done is just give you the background as to why this is being pursued, so.
Yes. And Director Hunter, you want to clarify on that or expound on it?
I think the county attorney laid it out. I think the other little small part is the state law directs the planning commission on a zoning map amendment to make a finding. And they have to show that the application is in compliance with the comprehensive plan. In absence of that, it gives them two other options. So the planning commission's job is to review any zoning map amendment under the authority of the comprehensive plan and make a determination whether they feel it meets the intent of the comprehensive plan. Then when it gets to the legislative body, as you heard, you guys can take action or take no action or have a hearing. But I guess in theory, if you were to overturn the planning commission, you'd have to make some kind of alternative findings independent of what they did. But the planning commission's findings in coordination with the applicant were submitted and basically are saying we feel it meets the comprehensive plan intent.
If the court were to approve, what we would typically say, and that's how our ordinance typically read, is that based on the evidence as submitted from the planning commission, the findings contained therein, and that it does comport with the comprehensive plan, they vote to approve it. You are correct. If they are going to deny the request, the map amendment, they would have to set out what they have taken from that record that causes them to vote in such a fashion.
Correct.
All right. Just as a note, we do not have a quorum to vote, so we won't proceed on any recommendations. The committee can always make a recommendation to the full fiscal court. However, when the fiscal court takes up the matter, obviously the fiscal court operates above the committee level with any majority vote. So, meaning that, for example, the second reading of the text amendment that we will take up momentarily has already had a committee recommendation. This item will go to the fiscal court in this meeting, their next meeting, without any committee recommendation. Yes, Squire Gill, you're recognized.
Just a couple of points. Well, first of all, this individual has met all the requirements for the comprehensive plan, but Mr. Shine at your meeting pointed out the fact that the footprint of these small communities is about the size of, some of them are close to the size of Versailles, and there's been concerns voiced for a long time. You all asked for a moratorium on in-family conveyances, but it seems like we've got more than the problem of in-family conveyances. We have these small communities, and they can go down to, are they allowed to have an acre lot?
Potentially an acre. Correct.
Yeah, they could have down to an acre lot in that whole area. And then in the conservation district as well, we're going to smaller lot sizes there. So I don't know, this kind of highlights a bigger problem, I think, that we've got in the county. If we're trying to save prime farmland, this isn't the way to do it, I don't think.
Yeah, so the zone change application that night barely touched on kind of that philosophical issue, but it's interesting in the committee when we get to the second text amendment and we talk about the A4 small community zone, that's what I think was described as these footprints are set in the comprehensive plan and in the zoning ordinance. Mm-hmm. And the theory was, if in the perfect world, when we get to the point in the zoning ordinance where we're in chapter 5, where all the districts are, that we might revisit these footprints. Maybe some need to be a little broader, maybe some need to be a little smaller, maybe they don't need to be radiuses, maybe they need to, for example, the Millville might need to, it just go all the way over to the river, for example. I mean, they just were set as radiuses, 1.5 mile, 1 and 1, and they've just historically been there for a long time. But the theory was that the zoning ordinance should lay out what's allowed in the zone, and the footprint of them should be defined by the comprehensive plan, which is maybe 6 months or a year away. So at this point, I think we just recognize that's what they are. When you open the comprehensive plan, that's the map. That's the land use district map that says where the A4 zoning footprints are eligible. And it is a little odd that the comprehensive plan and the zoning ordinance use the same term for a land use district and a zoning district. But the zoning is actually the A4 footprint, and then the boundary is really a jurisdiction that's designated by the comprehensive plan. And so the discussion was they're big, and at some point they should be revisited, and maybe they should be bigger, smaller, some difference, but we're just not at that point in the comprehensive plan to discuss that at this point.
Squire Brown, you're
Judge, I know all about that, and I was at the meeting the guy that talked about Millville could be biggest of our sales, which I hate to say this, he don't know what he's talking about. When they done all this, they figured they was trying to keep the schools. So the reason why Millville is a mile and a half is cause of the creek and stuff. Because you can't build in a creek, so they gave them more, half a mile more. The rest of them is a mile because they figured how many houses could be and stuff to try to keep the school. And they can't do it. If you want to see what's really going out in the country, just go out there now and go on McCown's Ferry, and you see when we switched over from 5 to 10 acre tracts and stuff and went to the other tracts where you can do 10 acre, well, there was 10 acres, you could do 5 acres, 10 acres, 15 acres, 20 acres, and about right where I live, it's about a little bit more than a mile. And we got a person now that's coming on McCown's Ferry to do some lots is in the mile. So the radius of the mile and stuff, you could, what he's trying to say right now, he's not going to go by what the mile and the mile and a half, changed it to further or less. But the biggest thing that I want to bring to the court, it's fine whatever you do, but it's a lot of misunderstanding. And they spend a lot of time and money on it. And it was something we need to look at and be slow about, because it's just like what she just said, that cannot happen. Because you got to go to Millville and see how that is. And that's why they just didn't do that real easy. They spent a lot of money and lawsuits and everything, all that. So.
And Squire Brown, may I ask you to yield to a question?
Yeah.
This being in your district, are you suggesting with this zoning map amendment that we're looking at that we take this slower, or the bigger discussion about the text amendment? I guess I'm asking, are we looking at this zoning map amendment on Cummins Ferry, or is your discussion about the text amendment in general?
Well,
Or
can
would
I
we
ask
like to
him a
take
few
them both?
questions?
Sure, yeah.
Are you going by what our zoning is, like the acre and a half? I mean, not acre and a half, a mile and a half? Or are you going by the new zoning that you got in here?
We're following the existing comprehensive plan. It's that map right there.
Okay,
And that's what the project was reviewed under the current comprehensive plan.
so it is in a mile.
It's right there. There's the circle. The
Oh,
blue
well,
dot.
is it a mile?
It-
It is in the mile, right?
Yeah. It's in
Okay.
that red footprint is the small community map, and that represents the project that's being proposed to be rezoned is in that footprint, which the comprehensive plan says the A4 zoning is an eligible zoning
Yeah,
in that
I
footprint.
agree with you.
Yeah, and then the A4 zone by default can be as small as a 1 acre lot. They chose this to be 6 acres, but in theory, so again, we don't want to speculate on what the applicant's doing, but in theory, if the frontage worked out, that 6 acre tract could get smaller someday, to your point.
Well, let me ask you this.
Right now, it's a 6 and a something, but because it's a 1 acre zone, any of those greens that you see there can always get smaller without having to do anything but file a plat.
Yes.
Yeah.
Squire Brown.
One more thing I'd like to ask you. The people's coming in, are you going back and look at how long they own the land? Like if you do a family conveyance, they pass word that you have to keep it 5 years. Now you can go on and build on it. The person can build on it, but they were supposed to save it for 5 years before you sell it. Now the people coming in, are you looking at that?
This
Are-
wasn't an in-family conveyance.
That's not what I'm asking. The other people, because for some reason we've had a lot of people come in for family conveyance, this and that, and I can't understand why they all suddenly they got word. So when they come in and ask you that they want to do one, are you looking at how long they've had it?
Sure,
Or okay,
sure, yeah.
so everything you passed
Yeah, we have
or
to go
trying
back.
to ask us to pass your in
Yeah, well, you,
the part of it.
well, these in-family conveyances don't come to fiscal court, they just go to the planning commission. But before the planning commission passes a plat, we have to establish that it meets the 1990 threshold, and then how many lots have been cut off the parent track, and then we have to verify they're eligible as a family member to family member. That is part of the technical review committee process when we, for example, we did 6 in-family conveyances the same night. So we have to go back, but we're not surveyors, so we don't do all the background research.
Yeah.
We just review the standards of the ordinance that they're meeting the thresholds to be eligible to be subdivided.
Well, how do you know then if you don't, how do you know how long they've had the lot?
Well, when they're starting one, when they're cutting one new, there is no threshold on how long they had to own it. That's just once you cut it, they have to keep it 5 years. But when they come in to propose to cut it, it just has to be a farm that was in play from 1990 and be eligible under the sliding scale.
Yeah, but they gotta wait for 5 years. They can build on it. It was my understanding, they gotta wait 5 years before they can sell it.
5 years to sell it, there's no other 5-year provision other than they can't sell it for 5 years.
Yeah.
But when they come in to subdivide it, we're not reviewing anything that, other than it's a farm eligible from July 16th, 1990.
Well, how do you know when they're gonna build on it or anything?
That's up to them. We don't until they turn in their application.
Yeah, but how can you approve it if they're supposed to keep it for 5 years?
We're just approving the subdivision of the land. It really has nothing to do with the construction of a home. It's just the subdividing of a
Well, they can
parcel.
go on and do it and y'all can't turn it down, right?
Yeah, we don't. If they come in and file for a building
Is
permit.
that something you've done or did Petty do that too? Is that something that's been doing all along with Petty? Cause that's why they had the 5 years on there. So we wouldn't get in a problem with just people doing acre lots and,
Yeah. I just know they come in to propose a division, and once they subdivide it, then one of the lots, when you subdivide one lot into 2, one of those lots is held under the 5-year threshold of the one who's been conveyed to. The property it's conveyed from, they can do anything they want the next day. There is no provision to hold anything. As far as building houses on 2 lots, that's up to them to when they pull. Well, all we're doing with the in-family is subdividing the property, for example, from 1 to 2. That's all we're doing.
and it's gotta be off the road.
Yeah, all that.
So
But
far
whether or
and all
not,
that.
when they decide to build or never build or sell, but the issue is, one of the lots is held for 5 years, the other lot could be sold the next day.
Why is that?
Because there's no provision to hold both lots, you're only holding the lot that's being conveyed to. The lot that's coming from is under no provision.
And let me
And again, that's not really, that's not.
let me interject here real quick.
Yeah.
So one of the things that I was getting at is we have a specific zoning map amendment, and then we have this greater discussion. The greater discussion is going to happen in greater detail.
Correct.
The reason I set this meeting so early in the afternoon is Exhibit A. This is going to be a lot of discussion. There's a lot of fine detail that we got to understand, history to discuss, all that sort of stuff. So zoning map amendment for Transition Range LLC, 3081 and 3151 Cummins Ferry Road, A1 to A4. We've discussed that in committee. If the fiscal court, when we get to our full meeting, would like that to remain in committee for a recommendation, then we can do that for our next meeting. We can also move forward with it. It will be the purview of the court. And I would always defer to the magisterial district that it's in, and if Squire Brown has a preference on that, then we welcome that. Yes, Mr. County Attorney.
And to comment on that, since you didn't have everyone, you could go on, even though there's not going to be a recommendation coming, and those on this committee can give what their opinion is and would have been and vote would have been to present to the court for the full court's consideration. So the only difference is not an actual vote, but you're still hearing from the committee members as to how they would have
Yes,
voted on the matter.
that's exactly
Because
right.
that could save you a meeting if that's what you wish to do.
Yes, or probably more, it would save an agenda item on a
Yes,
meeting. I imagine
yes.
we'll continue
Yeah,
to meet
not
on these
meeting,
things.
correct.
So let me move us one item down the agenda. So we have looked at 9042, 9048 Clifton Road, A1 to A4, we have a second reading on that. We have a committee recommendation. We should be able to dispense with that in full fiscal court. We just went over 3081 and 3151 Cummins Ferry A1 to A4, and the committee is still out on that discussion. So let me move to 720 Delaney Ferry Road, R1B A1 to A4 district. So, Director Hunter, do you mind to share information on those?
Yeah, so same night, December 19th, we had several zone changes. We had 2 city zone changes, 2 county zone changes, plus a text amendment and several plats. This is that zone change at 720 Delaney Ferry. You can see that parcel up there on the screen with the blue dot. It also fronts Carpenter Pike, and it touches Delaney Ferry. So that's the aerial of the property. This is a shot of it looking in the driveway up to the house. This is the zoning map, which was interesting. So the front of the property is zoned R1B, which is single family. So that's kind of old zoning that's out in the county. You don't typically see single family or the R1 zones. That's normally in the cities, in subdivisions. But this property has the frontage zoned R1B and the back zoned agriculture. And it's only a 3.8 acre tract. So it's clearly not a conforming agricultural lot, only being 3 acres in size. And what the applicants requested to do was to zone this to A4, very similar to what you heard in the prior case. Number one, to get it all in one zone, because it's in 2 different zones. But their intention was to be able to subdivide that lot so they could build a house back there on Carpenter Pike, literally where that blue dot is, funny enough. But what happened is when they filed their plat and did their survey, it turns out there's a strip of land that goes with the parcel down there at the corner that runs up Carpenter Pike and actually locks them out of touching Carpenter Pike. They thought their lot touched both Carpenter Pike and Delaney Ferry. Turns out there's some little strip that goes up there, old deed, where the neighbor said, you actually don't have frontage. So they're not going to be able to subdivide, but they didn't pull their zone change. They said, well, we'll just zone it all to A4 for a couple reasons. Number one, we got split zoning. Number two, it's less than a 30-acre lot. That puts us in the proper zoning district. And then down the road, if we can figure out this frontage issue on Carpenter Pike, then we could subdivide it later to build a house in the back. Planning Commission reviewed it under the very similar stuff you just heard. We looked at the comprehensive plan. There's the radius. You can see the little blue dot, almost center in that small community footprint. And in this small community, you can see there's A4. Of all the small community footprints, this probably has more A4 in it than any other, as well as historically, way back in the day before there was small community, I guess you went out there and just zoned things single family, R1B. So you see some R1B, you see some B1, which are old zonings out in the county, which would not be under the current comprehensive plan suggested zonings. But you see all the A4 that has been rezoned over the years in this footprint. So again, they're just proposing to zone that little sliver to A4. And Planning Commission reviewed it, and I believe there wasn't much debate. I don't think any neighbors attended, and voted to forward a recommendation to the fiscal court.
That was unanimous, yes, sir. So again, let me open up the floor for questions regarding zoning map amendment 720 Delaney Ferry, R1BA1 to A4. Squire Gill, you're recognized.
Thank you. Reading the findings of fact on this one too, they've met all the requirements. I don't see how you can turn them down, but if it goes to A4, they can make more than,
It's
can they do more
3.8
than?
acres, so the most lots they could have would be 3. But technically, they have no frontage on Carpenter Pike at this point in time. So with their frontage on Delaney Ferry, it's 1 lot for the time being. They don't legally have frontage. They thought they did, and they're actually maybe even disputing that with the neighbor. So again, going back to their survey, which was this right here, when the survey came back, they were surprised to find out that they don't. It looks like they touch Carpenter Pike, but they don't. So, but their intention was to subdivide it into 2 lots, acre and a half or lots, because their house is up in the front. You can see it on that exhibit. It's an older, smaller house. They would like to build what she described as her dream house someday, further back in the field, and maybe her mom live in the front house or sell the front house. But so they went ahead with the zoning because they'd already filed the application. They didn't know till later on that they weren't going to be able to subdivide the lot. So right now, the way it sits today, it's 1 house, 1 lot. But if they ever work out this frontage issue with the neighbor, they might be able to cut it into 2 lots, maybe 3, but it's unlikely to get to 3. It's probably 2.
Well, I don't think we have much, I think we have to approve it because, like I said, they met all the requirements, but I hope, and what Squire Brown said made a lot of sense. They developed these small communities to save the schools. The schools are no longer there. So I'm not sure that we need to be cutting that huge area into 1-acre tracts, and I hope the planning commission will take that up sooner than later.
So yeah, and so I think the idea was if we ever get to the comprehensive plan, we could address the small community footprints and the goals. Another way to get there is in the zoning ordinance text amendment, for example, the 1 acre become a 2-acre standard, if we thought that was more appropriate to meet the directive you're saying.
Thank you.
Yeah, this is full participation. Thank you, Squire Varner. You're recognized, sir.
Steve, in the comprehensive plan meetings I attended, on the small community discussion, what I understood was folks were just asking if they could get stores, their neighborhood groceries
They
back.
wanted
And
more
I never-
services.
I never heard any discussion about, cutting these farms up to A4 and any of that thing. The most I understood in the discussions I attended was they were looking to put their little groceries back in the community so they didn't have to drive all the way to town.
Yeah, and the small
And get
communities
gas.
historically have had smaller lots in them, some of them less than 1 acre back in the day. I believe we got lots in them, they're 1/2 acres, 3/4 acres. The current standard is 1 acre, but no, I don't think anyone said stop subdividing the small community, but when you look at, I guess, the broader issue of just cutting up land in general, there's some properties being divided in small communities, some divided outside the small community, some divided through the rural clusters. Yeah.
Thank you, Steve.
Squire Brown?
I just cut it off.
Yeah.
I just got to cut it off.
Oh, you're good. You're good. This is good discussion. Thank you, members of the court. So we're going to take agenda item 720 Delaney Ferry. It will have no committee recommendation coming to the full court. But again, the full court may act on it as it deems. Or it can ask for more information, send it back to committee. It's the purview of the court. So the big discussion is still on Articles 2 and 7 of the text. That's the proposed zoning text amendment. But we're not there yet. We need to return to the proposed second reading of zoning text amendment Articles 3, 4, 5, and 9. And if we could take a brief recess, I'm going to go grab my notes. Take a brief recess. We're in recess momentarily.
Little skinny, dark-haired lady with glasses. She doesn't have any hair. She has a dog. All right, if everybody is ready, we'll reconvene. We are back from a very brief recess to look at. We are looking at the proposed second reading of zoning text amendment for Articles 3, 4, 5, and 9. And Steve, we just procedurally, we have given this a first reading. And it is ready for a second reading.
one of the important parts of this and pieces of this is the medical cannabis language.
Tail end of Article 5.
Tail end of Article 5.
6 to 9 pages of Article 5 should be medical. I'm sorry, actually, towards the end page.
Section, new, Judge, if I may, it's new section 511, medicinal
Yes.
cannabis facilities.
Actual page.
In ours, Steve, it's not what you presented to the court. It would be pages 69. It starts at the bottom of 69. And Judge, too, if I may note, this
Yes.
mirrors the language adopted by both city councils of Versailles and Midway.
Versailles did it in July and Midway in September. And as we mentioned, I think in a prior committee meeting, we waited so this could be on the ballot for the county side. And then once the vote was positive, then we just put the language forward. The rest of the text amendment is just housekeeping in nature, procedural things, additional notice, letters, signs, that kind of stuff.
And so, let me open up the floor for any member of the fiscal court to ask questions about this specific text amendment or have any comments or questions. Yeah, Squire Taylor.
Just the medical cannabis portion, or?
No, I was just
Okay.
identifying the medical cannabis
Okay,
portion
sorry.
as the part that has some time sensitivity. Mr. County Attorney, we're supposed to have that enacted by January 1. Obviously, it's Mr. County Attorney.
I don't think we have any dispensaries in it, but
Yeah.
we do need to get that approved. And again, much of this, as far as that provision goes, Squire Taylor, is more appropriate for the cities than the county. We'd be more along the production line, that sort of thing. But yes, we do need to go on, since the vote out in the county was to approve it, to go on and finalize that with our ordinance.
Well, my question actually was particularly about the assisted living.
Yeah, that was a
Facilities.
housekeeping issue on that.
Yeah, could you explain I mean, it's
Squire Taylor, do
essentially,
you mind give us a reference? So we can all follow
that's,
along?
let's see, it's 509, it's on page 61 is the first reference.
Yeah.
As far as article and section, you have that?
509.1,
And the page number at the bottom is, let me get to it.
yeah.
61, yeah.
Okay. Everybody where we need to be? Squire Taylor, go ahead.
And it's just that, I wanted, if you could clarify the housekeeping portion of it, the removal of the final development plan approval.
Yeah.
Because that's also referenced later in that same,
Two things. We know with this change, we no longer call things final development plan. They're called site development plans. And we changed the threshold of what a site development plan is. So that's in chapter 4, what a site development plan is. So we're, as opposed to just every assisted living facility would have to file a site development plan, the thresholds of the site development plan are defined elsewhere. So for example, if you have more than 8 units in an R3 zone, you file a site development plan. So pretty much every assisted living is probably going to have to do a site development plan, but I guess in theory, if someone came in and did a 4-unit facility or something small, it would fall below the threshold. But we don't need the development plan requirements spelled out in Chapter 5 specific to that use, because there's a catch-all provision in Chapter 4 that lays out when development plans are triggered for every kind of use.
thank you.
And we no longer use the word final development plan, so.
Open up the floor for additional questions or comments regarding the text amendment.
Well, and I'll just point out, page 4-18 lays out those uses now. What triggers a site development plan? There's 4 provisions that trigger it for commercial, whether it be townhomes, multifamily, or group living, institutional uses like churches, or industrial uses. So it has thresholds now when a site development plan is triggered. That's on page 4-18, section 410.4.
And Director Hunter, if I can, so this is going to be maybe confusion to people that have the numerical page numbers. I'm doing the
Sections.
sections, so this would be 7.7, and you have a new section 701.7, property development standards.
Chapter, so that's in the following, this is this text amendment or the prior one?
Is that the next one?
Yeah, chapter
Okay.
7's is the
Sorry
new
to
one,
jump
yeah.
ahead there. All right.
That's exactly why this is confusing, because this prior text amendment was chapters 3, 4, 5, and 9, and 7 and 2 are in the new
I
one.
apologize.
Nope.
I
nope,
apologize.
Nope, that's why.
That's why we're going slow, Squire Brown. That's why we're moving with
Yeah, you done a good job.
detail. Thank you, thank you. I'm slowing it down so much, I'm jumping ahead. My bad. All right. So, other questions regarding the first reading that we had on the recommended approved text amendment of the zoning ordinance? Article 3, 4, 5, and 9. Anybody have any questions or concerns regarding that specific text amendment that we've had our first reading? And my goal is, you're more than welcome to ask any questions anytime in the fiscal court meeting, in the full fiscal court meeting. But I'm trying to get into the weeds, deal with some real detailed issues. If we need to go back and bring things back up, then we can open it up in committee and then return to it. If we bring it up in the full fiscal court, we're probably going to be not as quickly able to make a decision. There may or may not be a basketball game tonight. Mr. County Attorney.
And I know this is a lot. I mean, it's an 80-page ordinance. One thing to keep in mind, you do realize if this is a second reading, it will be final. It'll become the ordinance law. But at any point in time, once this becomes effective, if you all discover things that you didn't anticipate or that you have a concern with, there can always be, initiating from this court or at the planning commission level, new amendments proposed or changes to these amendments. But the question is, are you satisfied at this point in time with what was presented to you to approve a second reading, which would make it, in effect, the law?
Well said, Mr. County Attorney. Okay. If you are following along our agenda, we have held discussion on our proposed second reading. We just got done with that for Articles 3, 4, 5, and 9. Zoning map amendment for second reading, Clifton Road. The proposed zoning map amendment for Cummins Ferry and Delaney Ferry. And now we're moving on to the big ticket item. The proposed zoning text amendment, Articles 2 and 7. Now, I jumped ahead and I started digging into that, and I apologize for getting ahead there. But Director Hunter, I'll let you open it up. I do want to respect our members of the Board of Adjustment's time. If they would like to weigh in earlier, then you're welcome to do that. If you'd like to be here, for the full discussion, okay.
You're not Board of Adjustment anyway.
Oh, excuse me, Agriculture Advisory Review. So, well, then we'll wait on the Board of Adjustment to get here.
Yeah.
If you all would like your time to be now, you're more than welcome to do that, because I don't.
We can wait.
Okay, so you'll be here for the discussion, and we'll include you at a good time. Then that's perfect. All right, Director Hunter, if you could kind of give us some starting information to go over this.
Yep, so same night, December 19th, PowerPoint's up on the screen, that we heard this text amendment. Again, confusing that there's two, but this is the chapters 2 and 7, and I want to give you some background information on that. And I am going to keep it really light and then just open it up for you all to ask questions. And we have two of our Ag Review Board members here, our chair and another member, so they may want to jump in here. And I'm going to refer to some things that they've weighed in on this, because a lot of this started with some of the things that they do. So again, this was December 19th, and before I go too far, this is the PowerPoint. As I mentioned earlier, this whole Chapter 2 and Chapter 7 amendment started with this in-family conveyance verbiage that, at some point the Planning Commission saw a lot of plats coming in and said, hey, what's going on? And so, as you remember, there was some discussion about us proposing a fix and coming to the court and asking for a pause, and I'll get to that in a second. But this night, December 19th, and I'm going to go through them, we did 5 or 6 plats to just cut off more lots. So this was a property in the county. This is the plat, cutting off 2 lots off a farm with cutting those lots off with no frontage. So this one created 1 lot into 3. We did here one on Kids Mill. This cut 1 lot into 3. We did a property here on Fiscal Pike. This cut 1 lot into 3. This was an odd one out here on Oregon Road because the property is shaped like that, which is another issue that we'll talk about in a second. And this one cut a property into 3. Again, the lots are shown up there, again, off the road, no frontage, sharing a driveway, which already shares a driveway with multiple other neighbors, which is interesting when we start talking about fire gates and other things we talked about in the past, the idea that there's potentially 6 or 7 homes off one driveway. But this was another in-family conveyance we did that night. And then this was another lot where they carved the property into 2 lots, another in-family conveyance from a husband to a wife. So that night that we took up the text amendment, before we even got there, we had a whole bunch of projects to get through first. And then this was one in the city that cut off 14 more lots. So when we got through all that, we had several zone changes, and we'll just rip on through those because we already talked about those. When we finally got to the text amendment, which will be here in a second, this is my letter that went to the Planning Commission saying, hey, we're going to do a text amendment. I want to start with this slide first. Where this all started going backwards is, if you remember, in 2023, we had comprehensive plan public meetings. We went out in the county 4 different times, and we asked for comments. By the way, the judge's prior intern I want to point out that Connor did this exhibit for us, and we carried it forward on Facebook and our website and all that kind of stuff. But we went out and had these public meetings, and as you know, we heard from the public about all kinds of stuff, as a magistrate's already referenced. One of the things we heard at every single meeting was about the in-family conveyances and about cutting up farms into smaller farms. We heard about traffic, and we heard about residential subdivisions and for sale. We heard a lot of stuff, but we clearly heard about in-family conveyances at every one of those meetings. Not sure I'll tell you it was one way or the other, or just brought up. So this is an agenda from the Planning Commission in September. In September of 23, the Planning Commission, it's hard to see, but highlighted down there in yellow, we had a parcel analysis report that the Planning Commission asked me to put together some stats on how many lots have been being subdivided in all different ways, whether they be through the in-family conveyance, the rural clusters, big farms cut into small farms, 100-acre farms becoming 30s, to get us some data on that. So we did that in September. And we also talked about in-family conveyances, and that's the rules on that. We'll talk about that in a second, but we discussed how the in-family conveyances work, how the sliding scale works, who gets 2 lots, who gets 4, who gets 7, who gets 10, all that kind of verbiage. That was in September. And then these maps were presented to the Planning Commission. Mr. Kenneth John sitting over there. It says his name's Phyllis Mattingly by the name tag there, but I think that's Kenneth back there. He did these maps, or GIS data. We invest a lot in this county in GIS. A lot of counties use the ad or try to do whatever. We have in-house GIS. Kenneth produced this, what he called rural land use map from 2016, and showed all the different lots and all the different sizes. He also did a 23 map, so you could kind of go back and forth. And it basically showed where were we in 2016 on cutting off track, or what were the tracks that were 0 to 5, 5 to 30, 30 to 100, and on and on. And then he basically showed us I'm going backwards. And then he did a 2023 map to show us basically where we were. That was done in August of 23. And as I mentioned, the Planning Commission was reviewing this in September of 23. And clearly it showed just from 16 to 23, we'd created another 209 lots by various methods, whether they be in family, rural cluster, whatever. We created 200 lots in that time frame, and that's what our GIS data showed. So we also showed the Planning Commission where those 209 lots were. So this was a spreadsheet that, and again, this is what I showed the Planning Commission at the December meeting, but this is also what was reviewed in 23, and I'm going to show you some committee dates. So we looked at every single division, whether it be an in-family, a consolidation plat, a minor plat, a rural cluster, how the lots were created and where they came from. And this shows that there were 209 lots. Those are actually application dates that went through the Planning Commission from 23 back to 16. Now there's been a year since then, and we've created another 50 or so lots. But at that point in time, we just went through every single one of them. And then in October, the Planning Commission came back to discuss this again, and that's when they decided to ask the fiscal court for a pause or a moratorium, if you remember. The Planning Commission came back and said, look, we've studied the data, we've looked at it, we would like to figure something out here, but we'd like the court to give us a little cover and do a pause. And if you remember right, the court, or you all remember, directed the Planning Commission to just come up with a fix and bring it back to us, I believe is kind of how it's paraphrased. At the same time, the Ag Advisory Review Board in October got together and met. They had their regular meeting at the first meeting in October and talked about this because they're the Ag Review Board and reviewed these numbers. And they came back and they sent a memorandum to you all dated October 24th, 2003. And they sort of went through some verbiage based on their expertise. And I highlighted this on this page, and I'll let them get up here in a second if they want. But they put together some facts about what has happened in the county with land subdivision, whether they be in families or minors. And it's interesting when you look at that page right there, and I'll try to get to it in my slides here, because I want to point some stuff out on that. I think I got it in here. I'll let them speak if they want to, but it's interesting. This page was written by the Ag Review Board, and then they passed this and sent it to you all. But the start of this page says, it talks about all that data on the page prior. You know, they looked at all the cuts too, and I believe Lori broke it into percentages so the board could see it, pro and post and pre-development. And then they wrote up this kind of document to you all. And the first one's very interesting because it says, this is an unintended consequence of decisions in the mid-1990s that created the rural residential zone and to continue to permit in-family conveyances. The purpose of these two decisions were to protect our most valuable and productive resource, our agricultural land, for future food and animal production while maintaining the tradition of family farming in Woodford County. Yet the evidence is clear these strategies have failed. So their conclusion was, whatever we did in 1990 and these policies we put forward, they're not working as intended. I won't go through the rest of their goals, but they list some goals of what they're supposed to do, and they get into some details why they think if we continue to cut up the county in this fashion, how it's counterintuitive and counterproductive for farmland in Woodford County. And I don't want to speak for you guys, but this might be a point you do want to jump in here because this was your all's document, and I don't know, Judge, they may want to comment on, I don't want to steal your all's thunder on that.
And so, number one, we would welcome you to speak. Just as a procedural matter, so I talked to Steve earlier, and these folks are basically on the agenda. So this isn't public comment. This isn't the public coming to express their interest. This is a subdivision of government coming to talk about an agenda item, and that's why they have the floor and are welcome to talk about anything and everything that they have related to this item.
And Judge, I also point out, I introduced this as evidence as part of the public hearing discussion at the Planning Commission, so it was part of the Planning Commission's presentation. That was the resolution that they put together in October of 23.
I guess what it is that I've been
And you mind just say your name?
Lori Garkovich.
Yes, thank you, Lori.
And I've been a member, I was on the original committee in the early 1990s that created the rural residential zone, did that negotiation, and I've been involved in this for quite a while. As the ARC, our goal is to do two things. protect agricultural land so that we can have food production in the future. Secondly, it's to do that in a way that enables farmers to continue to be innovative in identifying new and additional ways to secure additional income, to diversify their income streams, and to be able to effectively continue farming. I mean, to make it a family business that can pass from generation to generation. As AARC members, we really do, and we've talked about this before, but we really do go out every time someone wants proposes something that affects us, our purview of responsibilities. We do go visit the land. We do visit the property and walk the property and talk with the landowner. But in driving there and coming back, when we come back and have our discussions, we realize that for some reason or other, we are trapped in, as a community. I'm expressing this from my perspective, I think, and I think Skip's. We have really good intentions about protecting agricultural land, but somehow the processes that we have gotten ourselves into makes it very difficult to do so. And that negotiation in the 90s, which allowed for the rural residential clusters and the in-family conveyances, is a perfect example of two solutions made by committee that created a camel that doesn't work right, and in fact seems to be encouraging more land divisions into smaller and smaller parcels, but more critically creating situations where non-farm producers find themselves in competition with residential desirees, those who want a rural residential desire, who have far more cash resources to outbid those farmers for that agricultural land. Secondly, as more parcels get transformed into non-farm production units or acres, parcels of land, we are straining the public's infrastructure in these communities. We are creating situations that make it very difficult for farm producers, livestock haulers, whatever you want, anybody that's involved and engaged in that process of agricultural production, to carefully and safely move down their roads, because those roads were made for farm transportation. They were not made for suburban commuters who are speeding to their jobs someplace else. We do talk to the fire chiefs we require now a statement from the public water systems in these rural areas. Do you have the capacity to provide? And it's becoming clear that what we have done in this process is we have created a situation where it is more and more difficult for the fire chiefs to know that they have enough water pressure to fight a fire, and it's difficult for the public water systems to know that they have enough water pressure. And we think we have created a situation which makes it even more difficult for farmers to farm, because I'm sorry, farm production practices are not necessarily what non-farm residential owners want to experience across the fence from where their kids are. And so we're creating a situation that's putting pressure on farmland owners, both economic as well as cultural and social ones, to give up the ghost, if you will. Personally, my concern is, and I'll just say this as a demographer, we already see this if you talk to people who are in real estate in this area. We are becoming a climate change haven, with people moving from very distant places that have much higher risks associated with them to Kentucky, and especially to places so nice as you keep pointing out how wonderful our county is, They recognize that too, and this is the place they want to come to. And so the dollar amounts that are being played in that agricultural land system right now are just pricing out a lot of farmers. Pricing them out from young people who want to get into farming to do so, and pricing it out in terms of the intergenerational transfer of that property and those farms. And so we felt very strongly that one of the, unfortunately, the in-family conveyance, which was designed at the time to satisfy those who were opposed to the rural residential, has become a very efficient tool for people to carve up more and more of their properties. And it just, we think it goes against the fundamental goals of what we say we have in our land use plan. Skip, I'm gonna let you go on.
Thank you, Ms. Garkovich. Mr. Phillips? Yeah, please hang out, please.
I'm Skip Phillips, Chairman of the Ag Advisory Review Committee. I don't know for how many years. We've lived in southern Woodford County now for 26 years. I think a good example, and it's personal to me, we moved here from Shelby County, we had a dairy. Shelby County, and I can't quote you the ordinances, but they were very permissive. In 1978, there were 396 permits in Shelby County to produce milk. In 1998, there were less than 40. And I wanted to, due to the demise of the tobacco program, I needed to add land base, I needed to add cattle. We simply couldn't do it. The big thing that concerns me about this is every time you start dividing land, you're inflating the price. And by inflating that price, you're taking people who maybe are second generation like I was, farmers, people who maybe just want to start, and you're pricing them out of the market. And if that continues, it's going to squeeze most of them completely out. And that's my biggest concern about this from that standpoint. From just a personal standpoint of where I live, you know, I look at the resources that I have, and I understand the roads are not going to get any bigger. The water lines are not going to get any bigger. You know, our access to public safety is not going to change, yet we keep adding demand onto this finite resource the more we divide. And I'm afraid that's not being addressed or really thought about long term. You know, I just turned 60. I hope to be here another 26 years. I watched this summer, spend a lot of time outdoors, the number of concrete trucks hauling heavy equipment. And it was very noticeable to me this year for some reason. You know, I see myself being my father. I drive by a new house and I go, I remember when cattle used to graze there. But I understand, I'll get used to that. So that's not my biggest issue. My issue is the resources and the availability for people, especially young people. And we've worked with some great young people with the AARC, looking at ways for, you know, developing an additional revenue stream, you know, to be able to pay for the land and to be able to, you know, use things like a little farm store or wedding venues and things like that, which are wonderful because it brings people in here. It allows us to share this with people, which I really love. But I think that those are the things that we've really got to think about going forward because, you know, moments matter, and this is a pretty important moment. It just is to me, and we've got to really, and I understand the intention of the in-family conveyance, and I think that when it was done, it was probably the best thing that could be done. But the way it's been used now and the way it's changed, and I just think that it needs to be looked at and readdressed because that was many years ago and everything has changed. So, thank you.
Thank you, Mr. Phillips. And I would ask you all to think, and you all can comment on this if you'd like. The text amendment that we have before us that does not have a first reading from the court, do you believe that that in your view and your all's expertise as Ag Advisory Review Committee persons, is this where we need to go? Is your recommendation that this is where we need to go?
I really like it from the standpoint that it probably doesn't make anyone completely happy, because the easiest thing to do would be to say no development or loosen the regulations. The hard part is the middle, and I think this achieves that, and I think it's the fact that Planning Commission came up with it, they need to be applauded, because I know how much time had to go into this, but I think this is a good compromise to get us to where, instead of it being unlimited, that we actually have a ceiling. We know how many more lots can be carved off, and I think that's important too. So no, I really support it.
And I agree with that, but also just add, my concern is that there are some
Do you
want me to go
to the mic
just to make sure we're picking it up? Agricultural land, once it's gone, it's gone.
Yeah.
Once you pave it, once you build on it, that's it. It's not like this is we don't get it back again. And so we have to understand, I'm not sure if we've always completely understood that these are irrevocable decisions with respect to the quality and availability of a land resource that is going to become more and more important in the future than it already is. Because I think we've not accepted all that yet.
Thank you. And Mr. Phillips, we were picking up your comments from where you're standing, so you're good. But I really appreciate your all's input. I appreciate your service on the committee. I appreciate your care and concern and attention for this issue. So, Steve, I'm going to turn it back to you to continue moving forward.
I'm going to finish that pretty quick. I'm going to go back to this slide here that shows all the in-families that were in different plats that were carved up. As you know, I didn't get here till August of, I don't know, when was it, 22? Time's flying here. But if you look at this exhibit right here, 21 is down there. So 22, I got here mid-year, but you can see how many were done between January and August. And then 21's sort of towards the bottom, 20's at the bottom, 20 carries over here, 19, 18, 17, 16. So again, this goes back several years before I got here. These are the ones that have been done. And again, it only looks like 5 or 6 or 8 or 10, but you got to remember when they're taking one track, and I think the tipping point was we did one on Clifton Road, not to pick on that property owner, but they took one 20-some acre farm and cut it into 5 lots. So 1 became 5. So it's not just that they're doing it in family, but sometimes they do 2. And as you look at those numbers, again, 1 lot becomes 2, 1 lot becomes 3, sometimes they become 4. This has been going, we just went back to 16 because Kenneth found me a point in the GIS data that we had good data to track forward to produce those maps. So this has been going on for a little while, and I think everyone recognizes that.
It was also within that like it was also just over that 5-year,
Past the 5-year
the 5-year window.
So we researched that too. So with that, I'm gonna finish up, point out, so once we did the comp plan meetings, once the planning commission met, once we come and ask the fiscal court for a moratorium, once the Ag Advisory Board reviewed theirs, the Planning Commission then went to work on this amendment. And so we have what's called an advisory committee. That's 5 of the 9 planning commissioners. They look at when we're making changes to the zoning ordinance or the subregs. They met on December 14th, December 28th, 23, September 12th, 24, and October 10th, 24. We were doing 2 things at once. I know people say it's easy to do 2 things at once, but we were looking at these county-side rural divisions, and at the same time we were under a directive from the city to deal with affordable housing changes, what we'll call city-side changes, county-side changes. So we were in this room for these meetings, and we had some magistrates here, I believe. Several of y'all attended that. We had council members in here, and we were trying to sit through this committee and go through the R1 stuff and then go to the A1 stuff. After going through all of that, all these meetings, they spent several hours, probably a good dozen hours or better. It was decided to just focus on the county stuff and forward that to the fiscal court, and we'll hold off on the city side stuff. So you guys got Articles 2 and 7 that relate to changes to the A1 zone, the A4 zone, the RR zone, the CO zone, county side zones only. and we had to make a few housekeeping changes in Article 2, which is definitions. The city side stuff is way more involved. It's the rest of Chapter 7. It's a ton of definition changes, and we just paused all that to say, well, let's move forward with the county side stuff first, see where it lands before we jump into the city side stuff. And I know you guys have read about the manufactured homes and the housing affordability, that the city's asking us to make several changes in the ordinance on that. So this committee was studying both at the same time, and literally we were bouncing around in the meetings. It was kind of confusing. But we did that almost, well, you saw the entire year pretty much, and then we ended up with the changes. So with that, Judge, I'm not going to get into the specific, here's what's on every page unless y'all want me to. I prefer to just say, if there's any questions, I'd like to just explain to you what's on that page. But I also want to mention that I'm representing the Planning Commission's recommendation. I mean, they voted on this on December 19th and voted to send you a recommendation to approve this text amendment by a 6-0 vote. So I'm not going to editorialize or tell you my opinion. I think the better thing is if there's a question, I explain to you where it originated from, how they got to that decision, and then why it's in that particular place in the text.
Thank you, Director Hunter. And let me also emphasize several of the points that you made for the committee, for the court, and for the record. Number one, this is coming to us at our request. The fiscal court has requested this. This is not the Planning Commission going on its own impetus to create or do something. This came from us, and it is returning to us in due course. I believe that Mr. Phillips and Ms. Garkovich have emphasized and eloquently explained the crisis of the issue and the moment that we're in as a community. Now, we're taking our time. We moved very slow. That was a long time ago in terms of court meetings when we requested this, but it is back before us. I have assured everyone that we're not going to move quickly, but we're going to move thoroughly through this. But one of the things that we have to do is establish a basis of understanding, of trust about where we are, and understand that and agree to move forward without a question of what is driving this. So one of the things that I would note as someone who pays attention to things going on in the region is Woodford County is not isolated from this mass development of farmland in rural America. Central Kentucky, because of our unique and special farmland, is being targeted, and the pressure is more intense. I mean, I am editorializing that, but I think you all would agree. But I know that Georgetown and Scott County are putting together a rural task force to look at the subdivision of land across the Elkhorn Creek. I know other counties deal with this as well. So we're not alone. We're not doing something on our own. This is coming to us, and we're going to take it line by line if we have to and move forward. We will need to get to a decision point, though. That we don't need to let these things linger, but we also need to make sure that we have public input. And so I will, at the fiscal court's direction, my recommendation is that we probably hold a public hearing on this text amendment the first meeting of February. That may be one of more than one, maybe the only one, but there will definitely be some opportunity for public input. The reason that I say this, the first meeting in February and not our next meeting, is our next meeting we have a lot of business that we need to take care of that we didn't put on this agenda because of the storm this past week. We've been working on some stuff. So that is my preface to the in-depth discussion of this text amendment. We are here because we have dictated that we need a change to the ordinance. The Planning Commission has done the hard work and the hard job of making a recommendation. That's what they're there for, and I applaud Chair Perry and the Planning Commission for having the courage and the forethought to go through this. Planning and zoning issues can be very contentious, as we all know, but they did the best, in my opinion, with what they were dealt. Director Hunter has explained, and I'll emphasize, is an administrative arm of the Planning and Zoning Commission. He did not say, you need to do this, or you need to do that. But he informed and helped administrate the process to get here. That doesn't mean that the Planning and Zoning Commission did everything that we as a fiscal court believe needs to be done. That's why we're the fiscal court, because you are a direct representative of the people of Woodford County, which you know well. So, that's just some preface as we get into this. Director Hunter, with that preface, do you want to start talking about Article 2? Do we want to?
Well, Article 2 is pretty easy. There's like just 5 changes that had to occur in Article 2. So it's Article 7 where we get into all the, we're going to land on what happens with the in-family conveyance provision. But I'll be glad to walk you through the Article 2. But again, I think what might be just as easy as ask if there's any questions. But 2 is really simple. And I will go through it pretty quickly.
Yeah. I think it's easier to,
Okay.
as we've read this, as we've dug into it, and I appreciate our magistrates that have watched online or gone to these meetings. Thank you. That's the type of homework and representation that people appreciate.
Yeah. Article 2 is simple. So this is the cover page of Article 2. This is where our definitions lie. So we have tons of definitions. And agricultural use is an important one. So there is a state law that is very specific about what agricultural use is. It's in KRS 100, 111, subsection 11, I believe, or something of that nature. And it has a definition of what ag is. And it's got an A, B, C, and D. And we thought it was important to put the actual definition of agricultural use in our definition that you see struck isn't exactly in line with the state. It's funny, it's kind of a catch-all definition. It sort of starts off with about a farm is corn and crops and blah, blah, blah. But then it goes into about mobile homes and in-family conveyances. And it really kind of regurgitates a bunch of the stuff that's in Chapter 7 and it all got pushed into this definition. Chapter 7 needs to define what the rules of the A1 zone is. The definition, in our opinion, should just mirror what the state law is, which is items A through D. Someday there may be an E that deals with bourbon, would be my speculation. That's what I guess they probably hope would be. But these definition of agriculture, number A is what we traditionally think of farming, corn, crops, soybeans, cows, whatever, orchard grasses, hay production, whatever. B deals with small farm wineries. That's an ag use, and if you're that, you're exempt from planning and zoning. It's also important to know if you're under the definition of agricultural use, there's been a ton of court cases, which we call the ag supremacy stuff, that you are technically exempt from planning and zoning. So if you're a small farm winery under KRS 100, 111, you don't have to come ask the Planning Commission to do anything. You're allowed to do that, just like you would if you're in the soybean business or you're running cattle on your farm. Items C and D deal with horses, equine. So if you're in the equine business, training, boarding, shows, events, you're ag exempt when it comes to planning and zoning. So we thought it was important to get those definitions verbatim out of the statute and delete our old kind of piecemeal ag use definition that's been in the book. That's number 1. Number 2 is on this page right here, deals with our definition of what a family member is. Clearly, if we're eliminating the in-family conveyance verbiage and substituting it with just a straight exception verbiage, we don't need the word in-family scattered around the ordinance in other places. So that just strikes the verbiage related to in-family under our definition of what a family. We're keeping our definition of a family member in general because it still applies to single-family zones. But we had to delete the back part of that sentence because we're no longer using the term in-family conveyance. Rural residential is the next one. We're going to talk about that when we get to Chapter 7. And again, whole bunch of stuff in this definition that's really zoning standards, and it needs to be in 7. It's already in 7. We didn't think it needs to be in the definition. So then down the road, if you have to housekeep something in Chapter 7, you don't have to go back and fix Chapter 2 every single time. So we just strike a bunch of the verbiage in the rural cluster. We're keeping the 80-20 split. The standards are pretty much identical. We just don't think we need that section in Article 2 because we got all the language in Article 7. The next 2 are somewhat, I'm not going to say controversial, but they're different. For years, we've had this term tourist destination, and tourist destination expanded as what we call uses in the ag zone. And as you know, the tourist destination expanded is what gave legs to the RV park up in Midway. Before I got here, I think this group had been studying on that before I got here and even had a recommendation. The discussion was to take these terms out of the zoning ordinance. We have now a better catch-all term called agritourism that's already in there. You guys have already made that amendment. We've outlived our day for the word tourist destination and tourist destination expanded, which in a sense lets you build a restaurant or hotel either above a certain threshold or below. And we don't think we need those definitions, nor are we going to have those as allowable uses in the ag zone going forward. So they needed to be deleted from Article 2. And I believe that finishes up Article 2. So again, they were just housekeeping definition changes in general that then tie in with the changes that were in Article 7.
Yeah, Mr. County Attorney.
And so obviously some house cleaning would be dependent upon whether or not there are more substantive changes
100%.
like with the
Yes,
in-family
sir.
conveyance.
Yes, sir.
So that would all become moot if there's not a change in that
That's right.
regard.
We would leave 2 the same. That's correct.
All right, let's move on to 7.
So 7 gets busy, and there's a lot. So I don't want to jump past. I don't. Again, I may just, if there's any questions, or Judge, how do you want to pursue with 7? Or I mean, I'll be glad to go through it page by page, or the things that this is what I presented to the Planning Commission.
If you would, like you did with the Planning Commission, go page by page and ask if there are questions
Okay.
as we go.
Sure.
That seemed to work well in your
okay.
meetings.
So, this is chapter 7, and my notes are right here, and I haven't picked them up yet, but I probably need to start following them at some point. But I'm looking at the PowerPoint, and I barely can see it, by the way, just so y'all know. These work right here. I can't even see it, but I think I remember what's on it, so I'm just going off memory. This is the cover page of Article 7 that lays out our 20 zones. And I said this at the Planning Commission and at the committee meeting. One thing I thought was curious, all the county zones are up at the top. You know, you start with ag, and then you go to the A2, and then you go to the RR, then you go small community. Then we get to the more city zones, the urban stuff, R1, R2, R3, commercial, industrial. And then it was weird to me that the conservation zone, which is a county zone of importance, was way down at the bottom. So one of the changes we're proposing here is when we show you what's happened with the rural cluster, we no longer need the A2 zone. It really doesn't do anything. So we're proposing to move the conservation zone up to the top. That's exactly what you're looking at there. So when you get into chapter 7 and you look at 701, 702, 703, 4, and 5, the county zones are at the top, and that's how they flow through the book. And it's important, Judge, as I mentioned this, you know, being a planner, I'll just mention this. This is kind of funny. This came up. My wife mentioned this. My first job was January 1, 1990 at the ad. So I've just hit 35 years of doing this stuff. I don't even know how that happened. I'm also 60, by the way, Skip. That's crazy. But it's weird because going all the way back to when I was in school and we talk about planning and zoning, it's important to note that when you build a zoning ordinance, and I've been doing this since 1990 for different counties, lots of different cities, it's important to realize the ag zone is one of the most important zones in your zoning ordinance. The whole premise of planning, you know, started way back after World War II to either protect residential zones or protect farmland. It's the highest level when you think philosophically about what zoning is. We're about protecting farmland, and we're about protecting residential properties and the value in intrusive uses to residential. So it's not an accident that every zoning ordinance you open pretty much in America starts with agriculture and then flows into residential before we get into all the commercial and industrial and all that stuff. Agriculture is the highest level of our responsibility when you get into the land use planning. So it's an important zone. It's at the top, and I just wanted to point that out. That's something I've known my whole career, and I think it's important to be at the top as well as those other rural zones be right there with it as we march through this chapter 7. The second page that you got there, I'm gonna jump around. I'm gonna jump right to the ag page next. So you're on page 7-3. Let me get my book open so I'm making sure I'm following you. This is the ag chapter. This is the cover page of the ag chapter. And I want to point out something here because this is new. And I again want to recognize our 2 members of the ag review committee. One of the things we thought was important in this chapter is we had an intent statement at the top, and you can see it. It's being proposed to be struck through. It was just basically one sentence. It is literally one almost run-on sentence that talks about the ag. And starting with this group in reviewing this, it was important to note we thought we need more to kick off this book as far as a purpose statement to talk about what agriculture means in general to this county and then in overall. So we created a new purpose and intent statement, and that's that A through F that talks about why farming is important. But F is brand new, and I can tell you I've used this in other places, but these guys helped us wordsmith this and get this unique to here. We created what's called a right to farm policy. And just what you heard Lori say earlier, it's important in the ag zone. I know we cut off lots and we build houses under this zone, but it's important to recognize this zone has an intent purpose statement that's first and foremost is about agricultural production and agricultural prime lands. And the right to farm is something that needs to be clearly defined so people that move out in the county and build homes and swimming pools and realize that, hey, farm equipment, dust, noise, odors, that's part of farming, that comes first. That's what this right to farm policy says, and we thought it was important to put it in the book, kick off the whole chapter with this right to farm policy. So that's brand new language right there. And I thank these guys behind me because they helped us get there, and they are our Ag Advisory Review Committee for the county. With that, I'll turn the page to...
And Director Hunter, just
Yes.
as a point, I mean, I think that specific clarification of that intent, and even adding the purpose and intent, I believe that fleshes out what was originally conceived. This isn't a total rewrite. This is a absolute clarification in a time where we need to be clear.
Yeah. Judge, I thought it was disingenuous. The intent statement's been in our book for years. It's pretty cookie cutter. A lot of these ordinances were written by probably the ad years ago. Our ordinance isn't too
Based on
unique.
model language.
Model language. This intent statement, I think, is something special, and it kicks off the chapter and makes us understand why this zone is at the top of the list and why it's one of the most important zones in the county. And it says what right to farm means. You know, anything that's legitimate, historic, reasonable, we need to protect that. Yes,
Squire
sir.
Gardner, sir?
Yeah, Steve, on D of your purpose and intent, discourage premature urban growth on land best suited for agricultural purposes. What are our ways to discourage? What are we looking at to discourage?
So funny, this one kind of works in reverse. Our urban service boundary concept in the comprehensive plan is one way to do that. These changes we're talking about to discourage urban style, the in-family conveyance provision. Our lot sizes could be discussed. Minimum road standards for certain developments could be discussed. But when you read that, it says discourage premature urban growth. The question is, do we define people going out creating 1 acre lots in the county urban style growth? Or is that conducive to farmland? But in our A1 zone, we actually have a provision that lets people cut 1 acre lots through the exception. So one way to discourage that would be to address these exceptions that we historically have put in this particular. This is a 30-acre zone by right, yet we got an exception where you can cut ones.
And that leads to another question. What is the definition of a farm?
Well,
Acres-wise definition of a farm.
you know, that is the $1 million question. Literally the $1 million question.
No, I'm just laughing because the Census Bureau can't agree with that.
No one knows. So we have a definition in the state law that I mentioned earlier in that chapter 2. It says it's 5 acres. So for planning and zoning state law, it's 5 contiguous acres of doing all this stuff. For tax law, for residential properties, it's 10 acres. So if you want to be tax exempt, ag exempt under, you're 10 acres or more, right? But it's 5 acres for zoning law, 10 acres for tax law. But what is a real functional farm? At some point, we're not proposing to change the 30 acres. We chose 30 here. Can you farm 30 acres? That's close to a little bit more than I have. I don't know. Hobby farm, maybe. Back in the day, tobacco farm, sure. But could you actually soybean, corn, my family farm in Ohio, it's way bigger than 30 acres, or you're not going to raise soybeans on 28 acres and live there, you know, kind of thing. But what is a farm? It's undefined in our book, but this zone is a 30-acre zone. So, you know, we're not proposing to change the 30 acres, but that is an interesting question because maybe that needs to be looked at. Maybe this zone ought to have some other number other than 30 up or down. I don't know. The state law is 5 or 10, and ours is 30. And again, I'll defer to y'all, and I don't know what an actual farm is. It depends what you're doing, I guess.
The reason I ask that is because some of our major developments are on little acres.
Yeah,
You
sure.
know, 50 acres, 40 acres.
Sure.
And that, when you carving off that, you get a big chunk of land then it's developed.
Yeah, sure.
So that's just my point.
And I want to point out, on Kenneth's data that he showed, we brought back the court a recommendation on what to deal with the in-family, do some housekeeping in the A4, that kind of stuff, the RR, but we did not touch the 30-acre provision, and just so you know, the big farms are still being cut into 30s. Kenneth's data shows that, so we don't have an answer for that at this point in time. That's why, again, we asked for the moratorium and thought the comprehensive plan should be checked first, because we really need to talk about that first. Because at this point, if someone has a 300-acre farm and cuts it into 1030s, we can't stop that. And that is occurring at the same time that we're cutting off the in-families. We're also carving up the big farms, and once, as you heard, once they're gone, they don't come back. But we're cutting off 30-acre tracts, and you can do that under the law by deed without having to come to planning and zoning. Yes, sir.
Steve?
Yes, sir.
Did you have something, Mr. Spiker?
Yeah, I'm really confused because I lived when they done the 5 and 10 acre tracts, and you could do 20, 25. If you go on McCown's Ferry, you see what that looks like now. Okay, and we had also the acre a mile from the school. And the reason why they said they want to change all that to 30 acres and stuff to get rid of the road frontage and stuff off the road, where you'd have a 5-acre tract, a 10-acre tract, 20-acre tract. If you had a 200-acre farm, you would probably be able to put that away 7 lots. Okay, so then they come up and said, well, we don't want that anymore. It's road frontage and thing, and we want to go to 80-20, where you can divide your farm to a certain extent, but we want to 80% save the land, and 20% you could do rural residential. And then they also said that we want to be able, if you own a piece of land, for your son or daughter to be able to live on the farm, you could do 1-acre lots. They got to be 400 feet off the road, and they gave you, if you do everything they say, you get 15 lots on a 100-acre farm. But if you build a house 100 foot on the road, or 200 or 300, not 400, you got to cut down to about 6 lots. So now people start to use and then the grandparents started hollering, and I was involved in that, not in this other, but I lived down there. Okay, then the grandparents started hollering, we need our children, we're raising their grandchildren, we want to give them a lot to live here because we don't have the money to go to a nursing home and all that. So we fought about that, but that happened. And then now everybody's using it a different way what it was content to be. But if we change a bunch, of which whatever y'all think is the best, right now, if we stop doing all this other stuff, you're going to save still 80% of your land. Okay, if you go like you're projecting, come back closer to the road, where you're going to have more houses close to the road you can see before you couldn't see. Then if you go with 2 family conveyance on acre lots, and it's got to come from the road, then you're putting 2 more lots on the road. But if you put it back and leave it like it was, but do something with the family conveyance to a certain extent, what it's designed for, it look like me it'd be better, but y'all have to, talk about it, because anybody knows, where she's been through it and stuff, and you were in when they done the other, but don't you feel that they are doing stuff in family conveyance that we didn't mean to do, and then so I don't know if you read back where it says to husband and wife back and forth until you immediately children, son or daughter, and then they put in your grandchildren. So now you got all that, and then you're supposed to be able to have to keep this land. You can go on and build on it if it's your son or daughter or grandchild, but you got to keep it for 5 years before you sell it. So my question is, are we watching that and seeing that's done? Because if you don't, you're going to get a whole lot now that come on the road that it defeats the purpose of the 80%. I mean, we got to make sure we're doing it right to make what you want. So if we took care of the family conveyance to a certain extent and keep it 80-20, wouldn't we be better off? And not coming back to the road on anything? I'm just asking.
The 80-20 provision does not apply to the ag or in family. The 80-20 is for the rural clusters only.
Yeah.
So when you do an in family, there's no preservation component, there's no 80 split. The 5-year hold standard is only for the property being, so if I convey to my grandchild, he's got to hold it 5 years. I can do anything I want. I'm not bound to anything.
Yeah, but you can't, if you come to the road, you're not going to get that other 80-20 because they're going to take it away from you. Way it reads today, to my understanding.
Yeah, well,
Unless you show me something different.
So if I have 100 acres, I'm allowed to do either 10 or 15 in-family conveyances right now.
Yeah.
Okay, if I have 10 family members and grandkids and we cut those closer to the road, I could do 10. But what we see, like I showed earlier, the Planning Commission in December, we see a lot of in-family conveyances between a husband and a wife, which is interesting.
Well, we can do away.
Yeah.
Only thing I'm trying to say to the court, are we going to keep it 80 or 20, or are we going to change it we can go back to the road again? Because that's the only reason why they changed it, to save the 80-20. Unless I'm wrong saying it, you know. And that way you done what you done. I mean, you want it, the 80-20 to...
It was partly that, but it was a compromise of
Okay.
different intentions.
And I think the theory was, when we get to the in-family, oh, yes, sir.
I don't want to interrupt you, but Kenneth Johns had a thought or a comment on the. Kenneth Johns had a thought or comment on the stats, I think.
Yeah, when the director was talking about 30-acre lots and you all were talking about what is a farm exactly in the intent. And you have this in your data, but just to point out, from 0 to just under 5 acres,
Got it up there, Kenneth, I'll put it up.
in the A1 zone only, there are 685 units. If you combine all the 30-acre lots to the biggest lot we have,
It's up there, Kenneth.
yeah, but it's 810 units. So to have a 30-acre minimum, it's kind of lopsided.
Yeah.
Just in case you all didn't have that handy.
Yep.
So in your explaining this specific map,
Yes.
The 24. So we did a 23 map, but Kenneth came back before my planning commission meeting and updated these numbers through October. So I had a 24 map, and there were even more lots created from 23 to 24. But to his point, the average parcel size in the county got smaller. Right now it's 25.47 acres is the average size. But the majority of the parcels in this county are below 5 acres, funny enough.
That's what I was pointing
So
out.
when you look at the chart, 0 to 4.9, less than 5. 2,300 parcels of the 44 are way down there. They were carved off years ago, before there was planning and zoning, before there was a 5-acre rule, because they're less than 5. Or they were created under the in-family conveyance provisions.
And that doesn't include, that only includes the A1 zones.
Yes.
No CO zones, no A4 zones, no A2, no rural residential. Only the zone that is designated as the top zone in the county.
And to our Ag Review Board members' comments, you can see by the map the scattering to the southern part of the county, which ironically enough is where we have challenges with hydrants, maybe some water challenges. I mean, we got a lot of lots we're creating in the south part of the county. You don't see that many in the north for different reasons. Who knows why? These are established horse farms, established bigger farm operations. They might cut a lot here and there, but where we're seeing most of the lots being divided are we created these 30s, now the 30s are being subdivided again through the in-family.
Mainly
And that
into
map
1
reflects
acre
that.
lots, mainly into 1 acre lots.
1s, 5s, 8s, they're just different, Judge. Everybody, we just showed you several at the meeting. They might be 1.5. They're normally big enough to make a septic work, so they'll be 1 or 1.5, something of that nature.
Squire Taylor, you recognize.
Is that the 1,000 acre, is that the UK research?
Yes.
Yeah,
That's
that's
what
the
I
only
just,
one.
I bring that up because,
1,400 and a little bit.
Yeah.
well, I just wanted to point out that that's not privately held. I mean, that's public land, and so, again, it's not, that we're not seeing that for agricultural purposes for the general public, obviously, I mean, for individuals, but it is beneficial to agricultural in the general public sense, but.
And it's a great point, because the number up there that's, you know, standing here as a planning person, I look at that 100 to 1,000 and see 285. Again, I don't have my glass. I think it says 285. 285 from the 100 to 9999. Once those farms become 30s, every time you lose that 100+ acre farm, as you heard, it doesn't come back. So again, going back to the original question, what is a farm? If we think it's 100 acre, we're not doing anything to stop those type of divisions with this proposal. But once those hundreds get cut into 30s, or those 50 to 100 get cut into 330s, as those numbers dwindle, they don't come back.
Right. Director Hunter, Mr. County Attorney, did you have a comment? No, I'm sorry.
So, so I appreciate Kenneth putting that map together for us, because that's what really got this started, Judge, when you all asked us to come back and figure this out. I mean, this data is what we're making our opinions on.
Yes, absolutely. Director Johns, anything additional? Okay, so I'm just going to point out, this is the pace that we're moving. We're at 7-3. But this is the pace that I expect us to move at.
Yeah.
So it's not slow, it's deliberate.
Yep. So we'll keep rolling, and we'll jump to the slide here, and we go backwards.
And let me, Steve, while you're doing that, let me take a moment to let the record reflect that Squire Downey has been joining us for some time now. He is on camera. We have a quorum within the committee. Let the minutes reflect that as well. And we will take up the previous items at the end once we get further down with this discussion.
All right, 7-4 is the next page in your packet. And again, not much to talk about here. This is more housekeeping in nature. The top of 7-4, I want to point out, that's where we're striking the tourist destination verbiage. Tourist destination was a use allowed by right. Tourist destination expanded was a conditional use permit. So both terms are being struck from the A1. Again, they don't really meet the intent of what our agricultural zone's about. And we have an agritourism catch-all moving forward for a CUP.
Can I take you back to 7.3 real quick?
Yes, sir.
701.2 alphabetical paragraph C.
Mm-hmm.
The reason that you're striking public and then public or privately owned, what is the reasoning behind that?
Where's that at, Judge? Oh. Well, they'd be exempt anyhow.
Exempt anyhow.
If they're public, they don't follow planning and zoning. It's odd that it said public. I think, well, going back, this group studied all the uses and the CUPs and sort of decided, what really fits the ag zone. You could argue that golf courses in general really aren't farming, but historically golf courses need big land. They're outside your cities, country clubs, for example. And this says they're allowed by right. You could argue maybe it should be a conditional use permit if someone came in to do a pretty large resort golf course facility. This says you can do it without asking anybody. Maybe it should be a CUP. This has been in our book for a long time. And I don't think people think, well, it's a golf course, whatever. Well, what if you build a big golf course and it's got 60 parking spaces and it's pretty intense? You could argue, why are we allowing that by right in the ag zone? But we didn't address it other than strike the word public, because if it was a government, if the county decided to build a golf course someday, you don't have to come ask anybody.
And some of the people on the committee who farm, and I think Scott, if you talked about that.
And Ms. Gargovich, do you mind, for the record?
But we talked about the intensive use of chemicals on golf courses to maintain the quality of it. And then that raises issues around for surrounding farmers whose cattle use those water sources in terms of, water quality and the impact on that. So it was the intensity of the use, not just in terms of, yes, the land is still there, but it's how it's being used. And in how does that use affect the quality of the the surrounding agricultural land and land-based resources.
Thank you.
But again, we didn't suggest striking those things. We just
Right. No,
modified it
that's
slightly,
good.
Judge.
The main question was that it doesn't really apply, so
Yeah.
that's kind of housekeeping.
Yeah, and I'll tell you, 7.4 is a very interesting page. It's not a page that's going to get a lot of attention because there's a lot of housekeeping on there. But because we've got so many lots zoned ag that are small, and we're creating lots, we need some verbiage in here about other stuff that traditionally, this is language that goes in subdivisions, our R1 zone, but we didn't have good language in there about accessory buildings, fences, swimming pools. If you want to do solar panels, whether on your house or in the ground, we didn't have any language here. And traditionally, why would you? This is out in the county, but we're building a lot of homes in the county on 1 acre, and we had no rules about what do they do if they build a swimming pool. We had swimming pool rules in the residential zones, but none in the ag zone. So we just mirrored a lot of the accessory use verbiage that's in the traditional city zones. We had to put them in the county because we got a lot of houses going up in the county. So it's housekeeping in nature, but it's just interesting when we looked at that, what we lacked. The next page is where we get into our conditional use permits. And we really didn't change this much. I highlighted a few up on the screen. We already had the list, but we thought it was important to put agritourism at the top because that's the one that really is the one that has been revised recently. We're following the state directive on what agritourism is. We no longer need the tourist destination verbiage. So it starts with agritourism, bed and breakfast, short-term rentals. Those are all terms. None of these terms are really different. What we added in that list of conditional use permits is mine, quarry, and borrow pit. We got a couple borrow pits in the county now. That's where they move dirt around, scrape some topsoil, store it. We didn't have any language on what those are and how we treat those. This would be a conditional use moving forward. So if someone wanted to do a quarry, it's unlikely. But if they want to do a borrow pit, which is very likely, then they'd have to come get a conditional use permit. Right now, we don't really tell them we don't know what to tell them. We just say get a grading permit, start digging dirt. So we added that, and then plant nursery. We had something for nursery, but sod and tree farms came up. We had no verbiage about sod or tree farms. So again, it makes sense if you want to do a tree farm or sod farm, it'd be in the county. We made it a conditional use permit. And then the Ag Review Board looked at these for intensity and decided to put some caps on square footages on some of these uses. Because, for example, if you look at E, school, no big deal. If someone wants to do a school out in the county, right? It's a school. But what if it's a 100,000 square foot building? What if it's an 80,000 square foot building? It needs 90 parking spaces. At some point, the intensity is not compatible with the ag zone. So we put some caps on these developments. So if you want to do a school, 20,000 square foot, so a small school would be fine. But if you want to come in and build a 100,000 square foot facility, by the way, if it was a public school, they don't have to ask anyhow. They're exempt. But if someone wanted to come in and do a private school or something of that nature, an animal hospital in number L, again, if you want to do a veterinary clinic, no big deal, but what if they were going to do a 80,000 square foot building? At some point, it's out of scale with the rural character, so we put some caps. And then the other one's interesting. Number M, you should just say research facility in M, and this board thought it was important to put the word agriculture related, because I guess research facility means, could be DuPont comes in someday, right? I think the intention was if we're going to allow research facilities out in the county, under conditional use, they ought to be agriculture related. Not sure we got any coming, but it just felt too loose just to have the word research. So again, we took some liberties with some housekeeping that weren't part of your directive, Judge, from the court. But as we got into this chapter, we thought these are things that need to be fixed.
And that is the type of explanation I think the court wants to hear.
Yep.
And so I appreciate it. Let me ask you
Yep.
a question on J, solar panels.
Yes.
Solar panels are a hot topic in many communities and our community. On tracts less than 10 acres in size, what was the rationale for that, that acreage?
So the solar panels that we want to allow are what would be accessory to your house. So if you have a house or barn and you just want to do some solar to supplement what you do, that's fine. But if you have a standalone tract and there's nothing on it, and you're just, and it's, your plan is to cover up with solar panels, you're doing something different than just, obviously if it's a vacant 10-acre tract and you're going to cover up with panels, who are you serving? Are you actually building a mini solar farm? We put solar farms, by definition, the big ones in the industrial zone, but this is a catch-all that to make sure it stays accessory in nature. You got a barn, you got a house, and if you want to put 50 acres of panels on your farm to serve your farm, great. But if there's no houses and no barns and no garages and you want to do 10+ acres of panels, something else is going on than you just putting those on there to supplement your electrical output on your property. So the goal was to make sure this stays accessory in nature. It's under the accessory uses. It says you can do them, but if it's a standalone parcel with nothing else going on, we don't want a bunch of solar panels so you can sell your neighbor electricity or pump it back into the grid. That's a solar farm, and we clarified 10 was used as just a threshold. We could have made it 50. We could have made it 5. We just said, look, if that's your goals, and by the way, if you come in and that's all you're planning to do, it's really not accessory in nature.
Yep. Squire Varner, sir.
That was a good point, Judge. I was going to talk about the solar panels. And Steve, we've had discussions over solar panels forever.
Yep.
But my view on that is they should be on the building, and that way we eliminate anything being on the ground and anybody getting ready to. If you say 50 acres of panels, that's a lot of panels.
Yeah.
Now we're at a solar
Yeah.
farm. So we need to keep that as tight as we can
Yeah.
keep it.
Yeah,
in my
and it's
opinion.
interesting that this gets into the building code. It's a little still vague about how solar works under construction, but our building inspector's involved in this every day. So if your desire was to put panels on your house or garage, their structural integrity has to be reviewed. There's times you have to go ground mounted. You don't have the opportunity to put them on your building. So the goal here is under accessory. These are things that happen when normally you have a house on the property and we're building pools or fences or solar panels or whatever. But the goal here is not to allow someone to cover up a large area of ground that's not really related to their farming or residential operation.
To the primary purpose.
The primary, yeah,
Thank you, Steve. Thank you, Judge.
yeah.
So,
Could you say that it's for private use? I mean, I don't know if you can make changes like that now without having to go back to the
No,
drawing board.
I
But,
think-
I mean, just to say that they can't that their solar panels have to be for their use only on that property, instead of sharing it with their neighbor, or, getting a
Yeah,
few
I
extra
think we can
bucks
say whatever
given
we need to
solar
say.
panels.
This gets into this weird hierarchy of zoning. There's a definition of what accessory use means. There's a definition of what principal use means. They're kind of connected. There has to be a principal use to have an accessory use, and then accessory uses are these things. In theory, what we don't want to make sure, we want to make sure it's clear that if someone thinks, hey, I can just, because right now you can put a barn up before the house, so you sometimes can do accessory things first. The goal here is that someone doesn't think they can just go out there and put panels on a property with no other principal use in play. Yes.
okay. So I think
Yes,
we
sir.
probably need to mark that for some
Yeah.
additional discussion.
And-
Continue on.
Yeah, but I think the manager points out a good point, and I'll defer to our county attorney. We sent you all a text amendment. It's very busy, it's a lot here, but I think if you guys wordsmith some minor things in nature, I believe the court could make some tweaks. If it was substantive, we've talked about this before, maybe it does have to go back to the planning commission for a new hearing, but I think if there was some wordsmithing here that occurs at the courts, this is what they want the sentence to say, I think there can be some changes made like that under your guidance.
If that's what the court desires, yes.
Yep.
Okay, we'll keep going. Everybody doing all right?
Yep. All right, so we're on page 7-6. Bottom of 7-6, you're going to see some things that say permitted residential use types. We thought it was interesting in this ordinance, again, housekeeping in nature. We put this in these city side zones that you're going to see some other day. There was no clear definition of what can go. I mean, there's different kind of what we call unit types. There's the word modular, single family, manufactured, qualified, manufactured home. There's different terms in the state law. We wanted to be very procedural in every one of these zones about what unit types are allowed. What unit type you don't see here is the word mobile home. Currently, under that old definition, you could do a mobile home, which is a pre-76 unit, rough, and you could do a mobile home if you're on 5 acres or greater. Less than 5, you could do a manufactured home, is what the old rule said. We're making it real clear. There's a difference between a manufactured home qualified and a manufactured home. It's 2 different state laws, but either way, we're good with that. They look like stick-built homes, and by the way, you really can't discriminate against manufactured HUD-approved homes anyhow. So every zone now says what the unit types are. But it was important for that items E and F. Tenant homes are allowed now, and they're continuing to be allowed, but to figure out where the tenant home verbiage was, you had to go look at the mobile home chapter. So nowhere in the ag zone did it tell you how tenant homes. So tenant homes are they go in the A1 zone, and they're related to the A1 zone, but you had to go look at a mobile home park verbiage about what a tenant home is. So we just stuck it here instead. And then when we define it here in a page or so. In addition, this is brand new. Again, we've heard a lot of debate about farming and in families and people coming on the farm. There's been a discussion about accessory dwelling units. Accessory dwelling units are not permitted right now, so when people call our office, we just had one today, hey, I got a house and a farm, can I build a second home? No. That's what we tell them. No. One house, one lot. That's the rule. Unless you do the tenant home, but you got to be farming to get the tenant house. Can I build a house for my mom, my mother-in-law, my son? It's no, 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 no. You can do the in-family where you're cutting off a lot, but a lot of times people just want to put a second unit on the farm for their kid or their mom or their brother or their friend or whatever, and we tell them no. So we're opening up as a trial, because we're talking about the city side of accessory dwelling. So this would be the ability to put a second dwelling on your farm. It's accessory in nature, it's smaller in relationship, and we'll show you those. But we're opening up the door for accessory dwelling units that would be 50% of the footprint of the principal, so it's in scale. So that whether your kid wants to move back on the farm, your mom, you need to take care of your mom, you got a buddy who's just got out of rehab, needs somewhere to live, I don't know what, we don't care. We're going to allow it on the farm. And that's new. And so that offsets a little bit about this in family where every time you have to cut a lot and there's a potential sell. If someone really wants to get someone back on the farm, we got now a new mechanism to get them a structure on the property. And plus you have the tenant homes that you always had. And then we define those in this chapter as opposed to having to go look somewhere else. All righty. Any questions on that page? And we'll come back to that. We're going to go in more detail on that. All right. Moving forward to the next page.
Hey, Director Hunter,
Yeah.
when you talk about those additional units, are they able to be resold, made into an Airbnb, used for some other purpose?
No, so Judge, that's a great question because we're talking about these accessory dwelling units, and the city sent us a resolution, I think way back in 2020 before I got here, about talking about these city side. That's the fear of doing accessory dwelling units. Do they morph into short-term rentals? But the short-term rental, you have to get a conditional use. So if tomorrow someone builds an accessory dwelling unit on their farm and says it's for my brother, and then we find out it's on Airbnb, it's a zoning violation. You have to get a conditional use permit before you can do a short-term rental. So the accessory dwelling units are in theory are for someone that's living there that's not a short-term rental. They're living there as a dwelling unit in a residential setting, as a single family or whatever. But that's the risk of doing accessory dwelling units is do they morph into short-term rentals? It's a slippery slope sometimes. You let them build a little cabin down by the river. It's for my brother. And then all of a sudden it's on VRBO and we're like, oh, they just put a short-term rental in. So that was discussed in our advisory committee with the city council members that they're now a little more cautious about the accessory dwelling city side because they could morph into short-term rentals.
Yes. Squire Gill, you recognize?
That to some extent kind of answers the problem of in-family conveyance. If they say they want their family to live there, they can do this through the accessory dwelling. They just can't split up the farm and then sell it off
That's
later
right.
in small pieces.
Yeah.
So it's still a bigger farm, so yeah.
It's just a second dwelling on that farm, and it's accessory. You can only do one of them. The tenant houses, you can do so many per,
Yes.
X acre tract. You can do up to a maximum of 10. But the accessory dwelling units, you can only do one of those.
Squire Varner, sir.
Yeah, thanks, Judge. Steve, that accessory dwelling is, can it be put anywhere on that farm?
Sure. Well, if it's accessory in nature,
Yeah.
yeah, it can. But in theory, accessories normally, there's a principal thing that sort of dominates, and you kind of got a backyard for your pools and whatever. But for farms, we're kind of loose about accessory dwellings because people need to put barns in the front yard or a silo. In residential zones, all accessory dwellings have to be in the backyard. But on a farm, we're looser because, again, accessory structures they're varied,
So in all honesty, they can put it on a lot, and at some point, if they're not using that, they can zone that, sell it.
Well, they can't, but it's not subdivided
Can they
at this
come
point.
back through and get that some way to be sold?
I guess they could try to zone it or use the exception provision and come in and say, now that I build it, I'll try to figure out a way to cut it off so I can convey it. But in theory, the accessory dwelling unit, And by the way, it depends what they're building. I mean, a lot of people that call us want to convert space in a barn or over a garage, or, you know, they're not typically saying I'm building a second home, but some ask that. But I'll tell you, it's an interesting little dance we do at the Planning Commission, which is right down there, by the way. I don't know if y'all knew we danced in there all day, but we do. People will call and say, hey, I want to do this thing for mother-in-law suite. And we say, well, you can't have, it's one house, one lot. Well, how can I get around it? Well, if you build the bedroom and bathroom but no kitchen, it's really not a dwelling. So if you put, you know, if your son wants to live in the garage and you build a restroom and bedroom, it's not a dwelling, you're good. The minute you put the kitchen in, we got two houses. So no, just don't put the kitchen in, you're good to go. But people call all the time and say, I want to figure out, my son's moving back, got a grandbaby, they want to live here. And we tell them, no, you can't have a second house on the property unless you're farming and they're going to work on the farm. But that's how you get around it. You just do the bedroom and the bathroom and you don't do the kitchen.
Thank you, Steve.
Which is odd. Then they put the kitchen in 3 months later, and you know what happens. So.
Okay, so I think we've probably got time to go through
Yeah, and
7-7.
Yeah, and we're almost to the page I think you guys want to get to. Judge, this is the property development standards. We boxed them and deleted the stuff at the bottom, but really we didn't change anything here. We made one minor change on this property, or on this box, because one of the challenges we've been having, and I'm going to show you up on the screen, is we allow lots to be created like this in this county. People call them flag lots, whatever you want to call them, but these are odd-shaped lots where they're meeting the frontage requirement. Then they build a strip, and then they go back and carve off the back. Some of these were done as in families. Some of these are the 30-acre cuts. So what happens is people will take a big farm and cut them into 30s, and every 150 foot of frontage is an opportunity to cut another 30. Mm-hmm. And this is what we get. And I've been asked, you know, how do you, look at this one here. I mean, they're staggered on top of each other. And so down the road, someone buys that lot, builds a house. Someone builds a house in the front. They're sharing a driveway. It's emergency management, whatever. You know, you got people sharing driveways. You got weird fence lines. This is not a good way to subdivide your county.
No.
And I was asked, how do you fix that and control that? That's one we just showed you that just happened here recently where they did 2 in families on this one. So these are examples here in the county. That one's kind of pretty. It touches 2 different roads. So if you own that farm, it's a legal lot because it's got frontage, and then it drops down to 10 or 15 foot and it widens back out. Then you got houses stacked behind each other, all that kind of stuff. So I was asked, how do you fix that? Well, I think I mentioned it's a simple fix right here in this chart. What we do is we're not changing the lot width of the ag zone. It's 200 foot wide. We still have a 150 foot frontage requirement, and we have the 200 foot standard. But the 200 foot was imposed at the building line, which the developer puts themselves. If you impose the 200 foot at the setback line, your lots will be rectangle. It's simple. It's an easy fix. It's not. And then Kenneth created this exhibit right here that shows an example of some lots that were just carved off out on Scotts Ferry Road. Don't want to pick on any developer, but Kenneth did this exhibit to show with this new standard where you do it at the setback line versus the building line, some of those would have been fine and some of those ones would have not have qualified.
And so, Director Johns, you had a comment?
Yes, and looking at those flagpole lots, if you all remember our Firegate discussions and Rose Lane not necessarily as an example, but a lot of these flagpole lots are what create that Firegate issue and people getting lost way back on the farm because they don't really have a road that they live off of. They're sharing one driveway.
Yep.
And Director John, you might have explained that exhibit there. It's the same one that's on all the screens.
Yes, so this is where the Director Hunter was talking about having the 200-foot setback line being, or the width of the lot being at the setback line. So the colors green, blue, yellow, those kind of correlate with the color of the parcel that it was divided up in. You can see that the blue one and the kind of to the west of the map would have worked. The orange-yellow one at the top of the map, the purple one there in the middle, the green one would not have worked. The
pink one.
The pink one certainly wouldn't have worked, and that is the flagpole lot in this exhibit.
They brought that plat in, sorry to interrupt, Kenneth.
Yeah.
The 200-foot building setback was back there in the back. So when they bring that plat in, they put the building line on themselves and say, oh, we're 200 foot wide now. We're 150 out here, we went down to 15, but look, we're 200. And it's a legal plat, we have to accept it. By saying it has to be 200 at the building setback line, there's no way you can create that strip. They would have had to propose something else.
And this plat has already been
Oh, it's done, yeah.
done.
Yeah, and this was another farm that was cut up into, what, kind of 30s, 60s? There's an in-family on this, some 30s, and some of them are bigger than 30. This was a big farm that was chopped up recently to this exact point we just talked about. And now it's, I don't know if it's being offered for sale or something, but may still be being farmed, but it's definitely changed in configuration.
This is a good example of the way that the farms that are significantly larger than 30 acres don't necessarily use an in-family conveyance or the rural residential to break a big farm into smaller 30-acre farms and meet the minimum of the 30 acres.
Yeah, and I appreciate Kenneth doing that exhibit. It was just, I wanted an example to show the planning commission how, in a perfect world, one we just did, 3 of those lots would have had to been reconfigured. Maybe we would end up with some 60s instead of 30s. And going back to the zoning ordinance, there's how we fixed it by simply putting in parentheses that the lot width is now established at the setback line versus the building line. Just, again, I'll call those cheater lines right there, how we fix things in the ordinance without really doing much. All right, and then we get to this page right here, we're 7-8, and this is where we define the farm tenant homes. Again, before you had to go look in a different part of the book. Now it's in the ag chapter under special provisions. And then there's the accessory dwellings in the ag zone. Again, we allow these to be 50% of the floor area of the principal dwelling. So again, if you have a 3,000 square foot house, you can do a 1,500 square foot accessory dwelling. You got to put a parking space in. If it's, you know, if you're going to put someone in there, we want you to at least meet the parking standard. But we're not policing this in very detail. We're just saying there's a relationship here. Principal dwelling, accessory dwelling, 50%. And that would be brand new. This is new verbiage in the A1 zone. And then we're to the page you guys all been waiting for. And it may be a good wrap-up point, Judge, if we can get through this. I know you guys got court, because then we'll stop there maybe. But this is actually the verbiage related to the in-family.
All right.
So we're on page 7-9. And what you see struck in underline, and again, you guys I think are getting familiar with how we do this. What's underlined is new text. What's struck is the text we're deleting. And so what you see there is the in-family verbiage is all being struck. So what you heard earlier about what are the rules for the in-family, the 5 years, the 1 acre, the 5 acre, who's related to who, all that's right there. And we're simply replacing that with a way shorter paragraph. And it's not called in-family anymore, so it'd be, you know, you'd have to get used to not saying the word in-family. It's just called exception lots. Because clearly this is a 30-acre zone by right, and to allow lots to be smaller than 30, those are exceptions. So, Judge, that may be something the court wants to discuss in general. I mean, we didn't change. We left an option in the book to do something less than 30, but there was discussion that if it's a 30-acre zone, maybe the rule ought to be it's a 30-acre zone. That is the intent, and it relates to your question is then what's a farm? 30, 50, 100, 20? But we left the 30, we created an exception. So we are substituting an exception for an exception. But you could argue that maybe there shouldn't be an exception. It was done way back whenever. But what this does, it was way back. But this clearly, with this exception, it's pretty simple if you read it. 3 things, I don't even have to read the whole paragraph. If you have a 50-acre farm to 99 lots, 50 to 99, you can do 1 lot. If you have 100 plus, you can do 2. And all lots have to have frontage. This idea of creating lots back in the field with no frontage is a nightmare down the road for the points Kenneth pointed out about emergency management, houses stacked behind houses. Down the road, it all works when it's a family, but when it sells 3 generations from now, we're sharing driveways, or I got to rely on you, who paves what, who gravels what. It's not a good practice to create lots with no frontage. Whether they have a driveway or not, they can figure that out. But this provision now says all lots have, and by the way, by requiring frontage, it's less likely we're going to have a ton of these. Because some people have maxed out their frontage already. But this provision would be 50 to 99.99, one lot, 100 plus, two lots that have frontage. So the in-family verbiage, where we had this sliding scale where you could do all these lots, and I want to get to that real quick. Here's the chart right here. We showed this to the Planning Commission. The upper part of the chart, and let me point out, I'm not saying that all these lots could be created, but if you use Kenneth's data on the chart, and you look at the tracks 15 to 30, 31 to 65, the current rural's at the top. So it's a sliding scale. If you have 18 acres, you can do two in-families. If you have 100 acres, you heard you might be able to do 15, you might be able to do 10. Maybe you can't do them all, but if you maxed out the lots we have currently, with the sliding scale, there's over 8,500 lots could be created. With what we're proposing, the 50 to 99 to 100 plus, there's the number, 877, is that what that says? So there's an end in sight. I mean, by the change we're proposing, 2 or 1, you go from potentially 8,500 lots before someday we get done with this chop, 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 to 80. There still could be 877 lots, but that gets to the heart of, should there be an exception rule at all? And again, we did not do anything more but substitute a rule for a rule and keep the exceptions. Now, there was some debate, should the 50 be 100 or 30 or 25? These were what the committee came up with, was use 50 and up and 100. And to Kenneth's point earlier, this does nothing to stop the 30-acre chops by right. But these are the parcels that exist off his GIS in the splits, and that's how many lots could be potentially subdivided under what we call the new exception rule.
Judge,
Mr. County Attorney?
8,600 is not factored into what's already out there that could be built upon, that's already already been approved.
Sure, sure.
And that's how many? What kind of numbers do we have? Do you know the numbers?
Well, Kenneth's map shows that we have over 2,000 parcels that are less than 5 acres. We would have to go in and actually have him somehow figure out which one has a house and which one doesn't. And so how many vacant lots are out there now that could be built on? We don't have that number.
You have numbers as to what's already can be at this time approved, has been at this time approved, where there could be development that hasn't occurred yet? Do you have any estimate?
Just what's in the hopper right now. Like I said, we did 14 lots at our December meeting.
That was for sale,
Well,
city?
No, the 14 lots were out in the county. Those other 14 lots were in for sales. We created 14 lots with 5 in-family conveyances that night. Yeah.
So, Steve, Director Hunter, excuse me. Let me stop you there.
Yeah.
I want to take care of some business from the beginning of this planning meeting. Squire Downey can be seen and heard if we can pull up his Zoom. Squire Downey.
Here, Judge.
Thank you for joining us. We are going to, as a committee recommendation, I will entertain a motion to recommend for the full recommend to the county attorney to draft for first reading the zoning map amendment, Transition Reigns LLC 3081 and 3151 Cummins Ferry Road, A1 to A4. I would entertain a motion to have the county attorney draft same. See,
I'll make a motion, Judge.
okay, there's a motion on the table. Squire Gill, will you second that motion?
I'll second it, but I sure hope they'll look at the small communities.
This is, and just to be clear.
I understand.
Yeah,
I
I know you do.
understand
For everyone else, this is to draft.
Right.
Draft
Just
it
because
to
they've
move
met all
forward.
the requirements. They've met all of our current requirements according to our comprehensive plan. And, yep.
And so there is a motion and a second. And Squire Gill, I'll let you finish that thought as part of the discussion, if you would like.
The small communities are a big chunk of rural Woodford County, and right now they can divide it down to an acre and divide it over and over and over. And it might be 10 acres right now, but it could end up 10 1-acre tracts in that one little area. And, you know, we've got a real problem with, he mentioned infrastructure. Lori mentions infrastructure problems. Water is a huge issue. You need, I think, a 6-inch pipe. You need a 6-inch line to put a fire hydrant. We don't have 6-inch lines in the county. They're all 4. You can't put fire hydrants anywhere. This is a huge issue. And water supply is a big issue. So we really, as a fiscal court, should look at these things. And I'm just wondering, you know, they had recommended a moratorium. I know we're not talking about rural residential right now. This is a small community. But they had recommended that moratorium. I'm thinking maybe we should do that, at least for 6 months till we get this thing ironed out, because I've been watching these planning meetings since they asked for the moratorium. In every single meeting, they have multiple in-family conveyances and requests for A4 zone changes to A4 from A1. So I think it is rather urgent with the infrastructure problems that we have right now. Thank you.
Thank you, Squire Gill. So again, just to clarify, the motion is not to adopt or approve the zoning map amendment, simply to direct the county attorney to prepare for a first reading. And that motion is on the table. Any further discussion? Seeing none, all those in favor, please vote and signify by aye. Aye.
Aye.
Aye.
All those opposed, nay. The motion carries for the recommendation to the full fiscal court.
Judge, I'll have that ready for your January 28th meeting.
Thank you, Mr. County Attorney.
Thank you.
And I would move forward to the 720 Delaney Ferry Road zoning map amendment. Is there a motion to move forward with having the county attorney draft, the zoning map amendment for 720 Delaney Ferry Road, RB1A1 to A4 district?
I'll make that motion.
Motion by Squire Gill,
Second.
second by Squire Downey. Are there any discussions? Seeing none, all those in favor, please vote and signify by saying aye.
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 Aye. All those opposed, nay. And the motion carries.
Judge, I'll have that also for January 28th.
Thank you. We already have the proposed second reading of text amendment Articles 3, 4, 5, and 9 before the fiscal court. We did go over those again in committee for further explanation. Also, we had the proposed zoning map amendment for 9042 and 9048 Clifton Road, A1 to A4. Those are both on the docket for the full fiscal court's action in our next meeting. That being the case, that we will not take any action on the proposed zoning text. We will have a ordinance committee meeting prior to the January 28th meeting, for sure. We may have additional committee meetings as well. The timing worked out. We will also preemptively look at the first meeting in February, second Tuesday in February, for a public hearing on the text amendment that we're reviewing. There being no other business to come before the ordinance committee, we are adjourned and will reconvene in fiscal court momentarily. Thank you all.